Welcome back to Illinois Law, a service of the Illinois State Bar Association, and I'm your host, John Tice. We're discussing cases from the last term of the United States Supreme Court, and when we took our break, Judge Leonard Murray, and he's part of our panel here with Professor Cecil Hunt and Michelle Jochner. Judge Murray, you were talking about a case from the United States Supreme Court in the area of criminal law and about statements by a defendant. And if you had is there more to add to that, as you were saying, about how the court held?
Yes, I think what's very significant about the opinion in this case is that Justice Scalia's opinion established a 14-day time period for breaking custodial interrogation as being sufficient to suggest that the accused has been given enough opportunity to either consult with family, consider the factors involved in the accusations, and not have to be immunized again with his Miranda rights, as it were.
That 14-day, was that something the court came up with, or was that the law that was involved with the case that came before the court?
This is brand new law.
Okay.
And Stevens' concurring opinion suggested that he didn't think that there was any basis for this rule. There was some suggestion in the opinion that this would give police officers some standard by which to measure their conduct. Stevens thought that the Edwards rule was sufficiently clear enough that law enforcement could abide by Edwards and not necessarily need this 14-day bright line rule to govern their conduct.
Yeah, in fact, many commentators after the case have stated that they believe that that 14-day period is rather arbitrary and not tied to anything, right. Just pulled out of the air, so to speak. So it'd be interesting to see how that works.
How it plays out, right. And there was another case in the area of criminal law that, out of the last term, that you, would you like to tell us about that?
Sure. There's another Fifth Amendment case that stems from Florida, and it's Florida versus Powell. And what occurred in the Powell decision is that police officers executed a warrant related to Powell at his girlfriend's house where he was living. And in the course of executing the warrant, they discovered a handgun in a room that Powell was occupying. The consent to the search was given by the girlfriend, who actually was the tenant. But the problem for Powell was that he was a felon, and because he had this felony conviction, Florida law prohibited his possession of a weapon, which is a similar law in other parts of the U.S. He challenged the search at trial. And the issue in Powell was whether or not the Miranda warning given to him was sufficient to alert him as to what his rights were. And they had a standard warning that was adopted by the Tampa Police Department that set forth certain language in the warning. And the question in the Supreme Court level was whether or not the various paragraphs that were inserted in the Tampa Police Department warning told him or advised him that he had the right to have a lawyer present at all stages of his interrogation. And when you read the warning that they had in place, an argument was made on both sides as to whether or not it was legally sufficient to apprise him of what his Miranda rights were. There's another.
Yeah, go ahead. What did the court do with it then?
Well, it was split decision, but they deemed that the warning was sufficient. And what they suggested is that when you look at all of the paragraphs taken together, it was sufficient to alert Powell as to what his rights were, and therefore, by having executed this statement, he was apprised of what his rights were. And even though it could have been better formed, if you will, it was sufficient to apprise him of his Miranda rights.
Now, the last case you said was a 9-0 decision.
Right. This is 7-2, and it was authored by Justice Ginsburg. And the dissent in this decision was by Justice Stevens again, joined by, I believe, Justice Breyer. But what's interesting about this case, I think, are a couple other facts. One is there is a Supreme Court opinion. I believe it's Michigan versus Long, that sets the premise that if there's not a federal question involved in a case for which cert is requested, then the U.S. Supreme Court should not take the case. And the Florida decision is one that Stevens suggested there was no federal question present because the underlying basis for the opinion relied on state law. So since it relied on state law rather than federal law, there's no federal question. Michigan versus Long says there's no federal jurisdiction.
But the court didn't agree with that.
They didn't agree. They claimed that the opinion had enough references to Miranda and federal rules that it was in fact one based on federal law, so therefore they asserted jurisdiction.
And I think as well that Stevens in his dissent voiced the concern of a lot of members of the defense community that the court is slowly chipping away some of the protections of Miranda, and what a lot of the people in the defense community have been doing are trying to use countermeasures, seeking avenues to protect civil liberties of defendants, such as now videotaping all police interrogations or allowing in-court testimony of experts to, speak to the effect of forced confessions or police coercion. So if it's chipped away on one side, maybe they're going to find another way to compensate on the other.
Now, as long as, Michelle, I have a question for you then, because there's another very interesting case that came out of the court in the last term, and that is a case in the area of, well, I guess it's dog fighting, but also video and First Amendment rights. So what was that case?
Yes, absolutely. Well, that was U.S. versus Stevens, and that was an 8-1 decision, which was authored by Chief Justice Roberts. And, of course, the issue of dogfighting has been in the news lately, largely due to NFL quarterback Michael Vick's criminal conviction for participating in dogfighting and for him being sentenced to 2 years in prison for that. Now, this case deals with a federal law that was passed by Congress several years ago, which criminalized the creation, sale, or possession of video or audio depictions of dogfighting. And the legislative history of this rule showed that the law was aimed at something called crush videos, where literally animals are crushed to death as part of the depiction. So that's what the law was aimed at. But here the defendant ran a business which had a website which sold videos of pit bulls engaging in dogfights and attacking other animals. Now, because he sold the videos, but he was not involved in the dogfights or setting them up at all, he merely sold depictions of these dogfights, he was swept within the ambit of this law, and he argued that the statute violated his right to free expression guaranteed under the First Amendment, and the U.S. Supreme Court did agree with him. Writing for the court, Chief Justice Roberts rejected the government's assertion that depictions of dogfighting and animal cruelty were of such a minimal social value that they should receive no First Amendment protection at all. In essence, what the government was arguing was that there should be a categorical exclusion from First Amendment protection for any kind of depiction of dogfighting or animal cruelty. And to the contrary, Justice Roberts wrote that the First Amendment means that the government has no power at all to restrict expression because of its message, ideas, subject matter, or content.
So the case is not, even though it's about dogfighting was just the vehicle for the discussion of the First Amendment right of the individual who was this a criminal case where the person was charged with it?
Yeah, he was charged under the federal statute.
Okay. Yeah, but the Supreme Court's interest in the case was the First Amendment part of it, and their holding was that there is First Amendment protection.
Correct, because under this decision it does nothing to change the fact that dogfighting itself is illegal in all 50 states.
So the people who participated in the dogfighting, put it together, had they been able to find and charge them, they still could have been charged with that. It was just the person who was selling this video that was able to assert a First Amendment right.
That's correct. The court just found that the law was overbroad, that it would sweep in other forms of expression that were protected, such as hunting magazines or hunting videos. So it just found that it was a violation of the First Amendment.
Well, as always, the United States...
There's a long tradition of using the First Amendment in this way, to say that the content of the speech, in fact, the very essence of the First Amendment is to protect vile content, bad content.
Well, thank you. We have to wrap up. We have 2 more parts to the series. We have a couple more programs. This is very interesting, as always, on the U.S. Supreme Court. This is Illinois law. This is a service of the Illinois State Bar Association. and I'm your host, John Tice. Thank you very much, Judge Murray, Michelle Jackner, Professor Cecil Hunt.